afternoon. I would like to welcome you very warmly to the 6th Intellectual Property and Competition Forum.
Hi, yes, so I can take my hand down now. Actually, I was trying to find a way of raising two fingers after your English bashing. I'm pleased that that the French English bashing is starting quite so early in the panel. They can give protection all the way up the chain if you want them to, and the protection can be as broad as you write it to be. So have-made rights are the answer, and that's why you should be licensing at the top of the chain and using have-made rights down, and not licensing at the bottom and using exhaustion up. And now I'll hand over to Christian to give the other argument on that one.
I'll just go on holidays if you're doing the moderating as well as the speaking, Richard.
It's because the British do it so much better than the French. You have to accept this.
I'll be back in 15 minutes.
Well, actually, I think I can hand over to Marianne in the first place, because she has already made her point that have-made rights will not work. They will not work for a great number of reasons.
An idea I wanted to throw to our panel is, if the NP does not comply with the ASI, should an effective remedy be to seize the NP's Chinese patents in order to enforce the ASI in China? Because then the NP will not have any Chinese patents and accordingly should not be entitled to any FRAND royalties in China. I would appreciate your thoughts on this question and idea.
Thank you very much. That was very, very interesting and also an important point. I think the NPE and enforceable asset question, as it were. Maybe Zhu Jing, maybe you would like to reply directly to that issue and also dig a bit deeper into Chinese ASI case law, please.
Thank you, Peter. Actually, today we have a lot of interesting discussions, and we can hear that China was mentioned several times, and maybe those ASIs granted by various China courts are the most controversial things and topics tonight.
So if I dare to wish something in the end, and maybe Dan is already raising his hand to contradict, I would say that that judges should not only think about, do they really need to grant an injunction each and every time, but that they should also make use of the new tools that the change in law is providing to them, tools like use-up periods and tools like especially the compensation that is mentioned by law and law.
Ben, do you want to add something?
No, I was just going to say that even if damages were to change in Germany, I don't feel like the U.S. model for assessing damages is a model. eBay is a great model. Our damages assessment system is a disaster and shouldn't be copied. There may be a role for concepts of willfulness to address some of the negotiation choreography issues that that have been discussed much, but. Fundamentally, damages analysis still has to be economically rational.
And then your company is active on a global scale. Do you see one country in the world where you think the right middle ground was reached?